Good morning, it is 8:50 a.m. on Monday the 19th of April 2020. Good morning, it is 8:50 a.m. on Monday the 19th of April 2021. My name is Arran Hunt, I'm a partner here at Stace Hammond and I head up the Migration Partners team. As always, this is not legal advice, it is merely our commentary on immigration. If you want some legal advice, then give us a shout at visa@ssexlaw.co.nz. The email address is in the description below, or go to our website stacehammond.co.nz. I want to go through a number of things today, which will be a rather large, massive update. We're going to look at the coming announcement, hopefully, on partners of critical health workers. We'll look at the rumours that are swirling around, and sort of dealing a little bit about rumours in general. We'll look at the response from the Ombudsman that was received by someone complaining about the skilled migrant priorities prior to lockdown. We'll look at the change in legislation we spoke about a few weeks ago. We've now done a submission on that, and we'll look at the living together criteria and how that's evolved in the past few months for those doing a CPVV. We were looking at doing a piece on character issues, but Immigration New Zealand came back to us with a pretty unsatisfactory response, very little information. We're going to give them a chance to give us a better response before we do that piece. I think later in this week we'll do that. Generally this was based around the character issues for those doing a CAP application to come to New Zealand to do their nurse bridging course, and who were denied due to character issues. We are often asked to handle character waivers for clients on all visa types, from temporary through to residence visas. We typically get them resolved for clients. We're going to sort of cover that in a future video as to what it means and sort of where to from now for those CAP applicants, but also in general, what is a character waiver, what are character issues, what is Immigration New Zealand looking for, and what are the rules behind that. Now, for what we're going to cover today, we'll leave timecodes below so you can jump to the section that you are after. There is a number of different pieces we're going to talk about, so feel free to jump around to whatever you want to actually hear. So, first thing is regular viewers will know that we've been battling Immigration New Zealand for months to allow the partners of critical health workers to be in the country. The government was very fast to thank critical health workers for working through the pandemic, putting their lives at risk for all of us, but then was very slow to actually provide them any sort of assistance in return. The general idea being, thank you so much for doing a 16-hour shift at the front line during a pandemic, killing people around the world. Now go home to your empty house. And that was sort of the approach the government was taking. Now, we raised this with the Minister a number of times, and never got a response. He was aware of this issue, this whole issue the entire time, frankly didn't care. You can actually write to the Minister and ask for a ministerial intervention to sort of look at something which may have been declined by immigration. He's refusing to look at those from people who are offshore, unless it seems you are a movie star, a musician, child musician, the nanny of a movie star. Those seem to be getting these ministerial interventions. If you are merely a doctor or a nurse wanting your partner to be in the country with you, then sorry, the Minister hasn't been there to even look at your application. They just get dismissed saying, sorry, not going to look at that. So thanks to Tova O'Brien over at News Hub, who was able to get a question of ours sort of in front of the Prime Minister to make her aware of the situation. Now, a few months later, we're now hearing that we're going to have something coming through at some point today, in about an hour's time. The announcement's supposed to be not 100% confirmed yet. Tova would generally not write an article unless she was pretty confident about her sources, but we'll have to wait and see what does come through. We'll do a video probably later this afternoon. Working on this morning, meetings this morning, so this afternoon covering anything that does come through as to how it's going to work for those of you who are out there. I know we have a number of clients in the medical profession who are looking to bring their partners in, who have had more than a year away from them, and we'll hopefully have some great news for you later today. Now, I don't often say this, but if you do like the video, please do like it. It does help YouTube sort of put it into their algorithm and push it out to a larger crowd. We're just trying to get more information out there to sort of use to people who may find it helpful. We do videos once a week, more than once a week if there is news to put out there. So if you want to stay informed, please do subscribe, click that bell icon. Please, if you dislike the video because you dislike Immigration New Zealand or the government. Don't dislike us or our video. No, we don't make the rules. I wish we did. I think we'd have a lot more migrants, a lot more happier migrants. But we're just basically here to try and help people know what's going on with immigration. So please, if you like the video, if it was helpful, tick like and subscribe and share it with your WhatsApp and your Facebook groups. We did want to just mention, now I did just mention, yes, something that that we had sort of seen in the media from a News Hub article. I'm going to link to the article below. We do try to link where we can to articles to sort of give you what we're seeing. But we have seen a lot of general rumours going around the past few months, actually on a weekly basis, almost daily basis. We hear some other rumour. Clients will say, "Hey Aaron, we heard this, is it true?" Big thing last week was we had a number of people come to us on Tuesday saying we heard this rumour from an immigration guru, I had referred to online, about changes coming through the following day on Wednesday. There wasn't any sort of, that was in regards to points for skilled migrant, or sort of guaranteed tomorrow we'll have this change. Nothing came through. So we heard the rumour from several of our clients. I went to my contacts in immigration, went to people I know in government and said, "Hey, have you heard anything?" They asked and said, no, there's been nothing going around. It's not taking place as far as they were aware. And come Wednesday, nothing took place. So I just want to make sure, a little mention that there are times that rumours do come true. We do hear rumours from good sources, and I think once or twice we've sort of gone, there's probably something here. But most of the time a rumour is just that, it is based on nothing. It's one person says something, other people are anxious and they want some good news or bad, or just some sort of news, and they spread it and it goes around on that basis. So if you do hear things, don't take them to heart. Ask for source of information, where they got it from. Go official, Google Beehive press releases, see if there's anything from the government. We'll generally put links in place when things get announced so you can see what we're seeing. So just be very cautious as to what rumours are going around there. We also do see a number of people putting out videos that seem to just be to try to scare. And actually I've seen a few other lawyers comment the same that I've commented, basically saying, stop these videos, they're just trying to scare people. And they try to scare people to get them to become clients. So they'll be doing, a good example was the work visa changes for the middle of this year. They were originally planned for this middle of this year, but have now been delayed indefinitely until we don't know when. But they can't happen in 2 months' time, what people have been doing videos about recently. The only change being the change in the median wage, which is coming through. Now, we see videos of this going up all the time of, here's what you need to know about the upcoming work visa changes, when in reality, we don't know what's going to happen with the work visa changes. They haven't announced enough detail yet to say how it's going to work. But they'll still do these videos because they want you to, they want to scare you. They want to make you, use your anxiety to be fearful. All we can say is just look for things that are official. And yeah, we'll link where we can to things that do come out. Until then, everything you hear, until you see it officially announced, or until you see someone with authority saying, here's what it is, just be very, very cautious with rumours. They happen all the time, and it's daily, never the same. Now, the second thing we want to talk about today was the response from the Ombudsman. So thank you to Satish for this. Hope I got your name right. Now, in July 2018, there was a change made at immigration that they were going to change priority for skilled migrant applications. So giving priority to those with salaries at twice or higher the median wage, those who had occupations that required registration, and those who were employed by a government department. Now this was sort of informal policy they did internally, and then on the 24th of February they actually made a change. So A16.1, now as I'll mention quickly now, if you hear me say a letter followed by a number, this is a reference to the operational manual. The operational manual is immigration's basically rules. You have the Immigration Act, which is overriding over everything, and then you have the larger operational manual, and that's the actual rules that Immigration New Zealand apply. Now, A16.1 was changed in February 2020 to give discretion to the Immigration New Zealand as to how they prioritise. So at that point there, they could use it to say, okay, well, this is how we're going to give priority. Now, prior to that, they were required to give priority only to those people who had a job. So by giving this priority to those who had high-paying jobs with the government, or registered jobs, they were actually not following the operational manual. Now, it's also then a breach of Section 26 of the Immigration Act. They were actually effectively breaking the law because the law required them to follow the manual, and the manual said they can give priority to those who had jobs. So between those two dates, July 2018 to February 2020, Immigration New Zealand was not following the rules. They're not following the law. So as a result, the Ombudsman has recommended that Immigration New Zealand apologise to the complainants, that's nice. But more importantly, Immigration New Zealand have been recommended to refund the application fees minus reasonable costs and lodgement costs to the affected applicants. And these are recommendations, they're not enforced requirements, but generally Immigration New Zealand will follow the recommendations of the Ombudsman. We will be pursuing this for several of our clients who have lost their jobs during the lockdown and who are now sitting in the queue for a skilled migrant for a job they haven't got, but have paid thousands of dollars to immigration to get their application processed. Right now, immigration has merely just scanned the paper documents. That's all they've done. So we'll be using this as a way to try and get them a refund of the vast, hopefully all of their application fee, and let them withdraw the application. Before now, getting a refund of the application fee was very difficult. But hopefully this is now sort of an easier way to do it, as long as they applied between that July 2018 and February 2020 area, which a lot of people did, especially because not long after that the draws stopped. Now, it is important, it's also important because it shows that at times the government can go beyond the power it grants itself. So in this case, it didn't have the power to use that discretion until 2020, but it was using discretion that it wasn't allowed to do. We believe we've seen this recently with the COVID-19 powers that the government granted itself in May 2020. As you mentioned, I think it was 2 weeks ago, the plan by the government is to extend their COVID-19 immigration powers through an act that they put through last year by 2 more years until 15th of May 2023, and this is currently in front of the Select Committee. Now, we submitted a submission on that last week. We'll try and link to it below. Submission is closing last Friday. Now, while the powers under that legislation are generally good for migrants, they weren't generally a bad thing as a whole, it did allow them to delay applications. So it did allow them to say, okay, people who are offshore cannot apply for this period of time. However, and that was allowed to be done in 3-month blocks. They want 6-month blocks now, which would at least, I suppose, give people offshore the knowledge that it'll be 6 months before they'll be looked at again rather than 3 months. However, it only allows to do that for offshore applicants. It doesn't allow the government to prevent onshore applications or to delay onshore applications from being submitted. However, we have seen the skilled migrant draws being stopped in March last year, which is mostly people who are onshore. So this legislation does not allow the minister to delay those draws taking place. That's our view of the legislation. In reality, we believe that the delay in the draws is just to allow the minister to say that he has the skilled migrant draw numbers coming down, when of course they're coming down because it's not being added to, and it's still an absolute mess of a system. So in our submission to the Select Committee, we've basically said that the minister's delay of the skilled migrant draws is not allowed under this legislation, because this is impacting people who are onshore, not those who are offshore. So we'll let you know as to what happens with that. We expect the legislation will go through because the government has full control of Parliament. But it would be nice for the minister to realise that perhaps he hasn't got the ability to delay those draws. It'd be nice to see the skilled migrant draws restarting again for the 10,000 people of you who are sitting in the queue. Next, we're going to look at, for those of you who are looking at under CPVV to bring in your partners, the issue it seems is that many of you are facing and coming to us with is the living together. So it continues to be the biggest factor. Had a number of inquiries from people asking about this, and to some we've actually said to them, look, don't bother trying to do a fetch, because the chances are you'll go across to the foreign country, spend a few months there, you'll come back alone. because you're not going to fit into the criteria as to what living together is. So I'm going to read I wrote out an email to an inquiry a few days ago. I'm just going to sort of read through it now just to give you some advice that I sent to them, and hopefully explain a bit better about the living together standard and how it's being applied now, because it has changed over the past few months. So a few months ago you could do a fetch, that wasn't so much of an issue, now it really is. And hopefully this is a use to a few of you. So the issue that everyone is having is the living together criteria being applied by Immigration New Zealand. So while under H52515F, which is the operational manual section related to bringing your partner in with you, it doesn't strictly list living together as a requirement, but Immigration New Zealand have taken the approach that a partnership can only be seen as being genuine and stable when they have lived together. We've raised our disagreement with that with Immigration New Zealand on more than one occasion, but they are maintaining that is the definition requirement of genuine and stable, at least for now while the border is closed. We actually think that if this was looked over by the Ombudsman or by a court, we'd expect that this would not stand up, because the government and Immigration New Zealand have the ability to make changes to the operational manual to cover, to actually state that genuine and stable requires that. It doesn't state that. Our interpretation would be then it doesn't require that, but this is the way that they're seeing it. So E4530 is the section about living together, and I'll link to that description below. There's a few things to note here. The most important thing is probably the exclusion of time spent in each other's homes while still maintaining individual residences. Now, the way this is interpreted is that any time together won't be counted if you maintain another home. So for those doing a fetch where you're going across to another country to be with your partner and bring them back, if you maintain a place in New Zealand, they will see that as maintaining an individual residence, meaning that you are not there living together offshore. Even if you give up the home in New Zealand, if there's a job back in New Zealand you have to return to, Immigration New Zealand might go, well, actually you are sort of kind of living on a holiday together. You're visiting. You're not actually living together, because you have this obligation pulling you back to New Zealand at some set point. So generally, for those we've seen recently that have gone through, and they've actually gone through pretty smoothly, is when we'll be able to show that the home address in New Zealand is over, it's finished, and that they've got their mail being forwarded, that the job is no longer there, that they really are living offshore. And it really is about focusing on showing that you are living together there with no ties back to New Zealand. The other factor we've got here is that previously living together was an absolute. It was a we have or we haven't. It wasn't sort of, have you done it enough? It was generally a yes or a no. So living together could be claimed within a moment of living together. We've had applications we submitted for partnership work visas. When it being within a day or two of them actually moving in together, we've made the application, because from that point onwards, they were living together. It was a yes, absolute, definitely situation. Now they're seeing as they're factoring into sort of genuine and stable. They're seeing it as being a variable thing, a time-based thing with no actual set time frame. We raised one application with the head of the border control team, who has sadly gone on to another role now. And he agreed that the couple were living together, but it hadn't been long enough for the officer to be happy that they were stable. So they had met living together standards, but not living together to be genuine and stable, which is it's using discretion that they do have, but I think they're using it to a point where they're breaking that discretion. It's getting a bit crazy now, I think. For that situation, the couple had been living together offshore in a Western country for several months, but immigration still felt that it wasn't perhaps long enough without being able to say how long it needed to be. So that's the most likely issue that you are going to face if you do try to sort of do a fetch operation or bring someone in from offshore, is that view of whether you are living together based on the evidence provided, and if you are, that subjective view of whether it is long enough to satisfy the requirements of being genuine and stable. So that's basically where the living together situation is right now. If you're going to do a fetch, we strongly recommend you get legal advice from ourselves or someone else before you do what could be a very expensive holiday, which you return on your own. We've said with a number of clients, we've said to them, look, it's not going to be worth the risk. We advise against it because they could be looking at $10,000 plus if we factor in MIQ and airfares on nothing. So be very, very cautious. Get advice before you go. Please get advice before you go. Don't come to me after the fact and say, hey Aaron, help me, because it could just be, we can't help. So definitely look into it before you go. And that is it for today. We'll come back later in today with this announcement coming through, hopefully at 10 a.m. in less than an hour. The video will be up by then, regarding critical health workers and their partners, and whether it's going to go far enough to include perhaps New Zealand citizen health workers and then their partners. We have a fear that if they do make an announcement, it might forget that there are some citizens, residents who have partners offshore who are equally caught out. But we'll see what the government comes through with. And then we'll come back later in the week again for, of course, to cover the character issues and character waivers, a special video about just on that topic, to hopefully give you an idea as to how things work. We'll look at the IPT, the Immigration Court, how they look at character waivers, what the requirements are, and why we often see Immigration New Zealand perhaps being overly harsh, often before they get reminded as to how they're supposed to actually apply these rules. Until then, until probably later this afternoon, kia kaha, stay safe.